How to draft an employment letter for a successful H1B visa. I'm your host, John Veely, immigration attorney and CEO of Online Visas, the intelligent immigration platform. If you'd like to learn more about what we cover in this video, go to onlinevisas.com. In order to protect the interest of U.S. citizens and residents, the H1B requires a labor condition application, LCA, which is set in place to ensure equal opportunity, pay, and working conditions for foreign workers as U.S. citizens and residents. One step in this process is the LCA notice of posting. Essentially, this is a requirement that the employer formally informs their employee and the public in writing that the LCA is being filed. The notice of posting can come in two forms, a hard copy notice or an electronic notice. To post a hard copy notice after the LCA attestation is accepted, the employer must print and sign the LCA. Then they must post it in two conspicuous places in the work area where the beneficiary would be working. The notice of posting should be of sufficient size and visibility to be easily seen and read by persons in the work area. It's appropriate to post the notice in areas where other notices are posted, such as wage, hour, and occupational safety, and health notices. Places where employees frequently gather, so as the water cooler, are also appropriate. An electronic notice should be given on or within 30 days before the labor condition application is filed. It should be made available for viewing by affected employees for at least 10 days. The employer may make the notice available using any means it normally uses to communicate with workers, such as a homepage or electronic bulletin board. Electronic circulation, such as an employee newsletter, are also appropriate. If the employees do not have a readily available access to the internet or company intranet, a hard copy notice should be utilized. Rules for the notice of posting vary slightly depending on if there is a bargaining representative or not. A bargaining representative is an employer group or person who negotiates a proposed enterprise agreement on behalf of those employees to be covered by the agreement. According to the Code of Federal Regulations, if there is not a bargaining representative, the notice should include that H1B non-immigrants are sought, the number of non-immigrants the employer is seeking, the occupational classification, the wages offered, the period of employment, the location at which the H1B non-immigrant will be employed, and the LCA is available for public inspection at the H1B employer's principal place of business in the U.S. or at the worksite. The notice should also include the statement, complaints alleging misrepresentation of material fact in the labor condition application and or failure to comply with the terms of the labor condition application may be filed with the Office of the Wage and Hour Division of the United States Department of Labor. If there's a collective bargaining representative for the occupational classification in which the beneficiary will be employed, the notice should pinpoint the number of H1B non-immigrants and the employer is seeking to employ, the occupational classification in which the H1B non-immigrant will be employed, the wages offered, the period of employment, and the locations at which the H1B non-immigrant will be employed. In addition to posting the labor condition application, the employer must develop and maintain documentation to support the statements made in the notice of posting. The Code of Federal Regulations state that the employer should retain records for 1 year beyond the period of which the H1B non-immigrant was employed under the labor condition application, or if no beneficiary was employed, 1 year after the date the LCA expired. Moreover, the documentation must be made available for public in Department of Labor examination upon request. Attending carefully to all the steps of the labor condition application can help assure the best possibility of your application being approved by the Department of Labor. All required data should be included in the notice of posting and well documented in corollary sources to avoid disapproval of the LCA. If you want to discuss your company situation, go to onlinevisas.com and set up a strategy session. If you want to stay up to speed on the ever-changing world of immigration, subscribe to Online Visas, like, share, and follow us on Facebook, Twitter, LinkedIn, Quora, and Instagram. I'm John Veely, CEO of Online Visas, the intelligent immigration platform where we deliver dreams.